Today we'll hear arguments in the case Free Speech Coalition versus Paxton. Counselors, whenever you're ready.
Mr. Chief Justice, and may it please the court. I'm Lisa Wang, and this is my partner, Eileen Wang, and we will represent the petitioners in this case. We contend that the court should apply strict scrutiny to this case concerning Texas House Bill 1181, as its conditions abridge adults' fundamental right to free speech under the First Amendment, impose content-based discrimination, and pose security risks that create a chilling effect that deters adults from accessing these websites.
So, the First Amendment prohibits laws from burdening protected speech and compelling disclosure statements. The respondents' conditions implicate the First Amendment rights of adults and online platforms by mandating age verification on platforms containing over one-third of obscene speech. This burdens adults' legitimate access to sexual material by imposing a chilling effect that deters adults from following through with age verification because it complicates access and poses security and privacy concerns. Additionally, the law compels websites to disclose health risks, which violates the constitutional protections against compelled speech and undue government interference.
Furthermore, if strict scrutiny was applied, the Texas House bill will fail because HB 1181 is not narrowly tailored, as it demonstrates both over-inclusivity and under-inclusivity in several areas, including its content threshold, limited scope, lack of necessary distinctions, practical shortcomings, and its potential to cause harm to minors. Moreover, it does not employ the least restrictive means, disregarding superior, less intrusive alternatives, such as parental controls and filtering systems, and unduly burdens the rights of individuals outside of the targeted demographic.
What, if any, is the value of low-level speech, such as pornography?
So, the value of low-level speech, including controversial forms like pornography, often centers on principles of free expression and societal implications. Pornography can have redeeming social value if considered as a form of personal or even artistic expression of human desires and fantasies, as established in Miller v. California. Pornography can be used to explore sexual orientation as well, because viewers can develop an understanding of attraction to others. It can also be used to foster discussions of sexual preferences and boundaries in sex education or sexual therapy. Lastly, at the end of the day, pornography is an industry, so it does serve economic growth by generating revenue and providing jobs, albeit the exploitative nature of said jobs. Regardless of the fact that pornography may be deemed low-level speech, it is still protected just as high-level speech would be protected. Playboy established this when the court stated that one idea is as good as any other, which basically says that low-level speech is no less protected than high-level speech.
Thank you. Was the First Amendment created to protect this kind of speech, and does that matter here?
The First Amendment was designed to protect high-value or low-value speech, as it doesn't permit discrimination based on perceived quality or significance. This includes material like pornography, which, while potentially viewed as low-level speech, is still protected for adults under the First Amendment unless it meets the narrow legal definition of obscenity. HB 1181 seeks to restrict material that is protected for adults, but the First Amendment prohibits the government from suppressing speech simply because it deems it unsuitable for certain audiences. The nature of the value of speech is inherently subjective, so what is one man's amusement teaches another's doctrine, which was said in Winters v. New York. Either way, it would be difficult to distinguish between high-value and low-value speech, and it would be legally dangerous for them to try, as established in Brown. Although the amendment initially aimed to safeguard speech critical to self-governments, its adaptability extends protection to broader forms of expression, including those burdened by HB 1181.
Whose First Amendment rights are impacted by the Texas law? Is it minors, adults, or the platforms themselves?
So, the restrictions applied in Texas House Bill 1181 unconstitutionally burden adults' access to protected speech by mandating age verification for platforms with over one-third obscene content. This poses a significant security concern as adults who provide their identifying information risk things like identity theft and data breaches. Because of the risks inherent to website-based age verification systems, the bill results in a chilling effect, which really deters adults from trying to access lawful content on these websites. The digital privacy advocate of ExpressVPN, Lauren Henry Parsons, noted that potential privacy concerns that arise with uploading personal information through required age verification methods are incredibly severe. And lastly, the law also abridged children's First Amendment rights. While adults are heavily burdened, it is still possible for them at the end of the day to choose to access the material if they follow through with the age verification system, although it's incredibly burdensome and risky. However, for children, it completely prohibits them from accessing the remainder of the content on a website that is not obscene for children, all of which might have educational or artistic value, as stated in the amicus brief in support of the petitioners. As opposed to website-based age verification systems outlined in the bill, content filtering can be applied selectively to specific pieces of content rather than blocking the entire website.
Why can or can't the government simply ban access to pornography online?
The government can't simply ban access to pornography online due to the constitutional protections under the First Amendment, and because it has some sort of value. The Supreme Court has ruled that non-obscene pornography is a form of free speech in Reno v. ACLU, so a blanket ban would violate these protections unless it was deemed legally obscene. Moreover, since not all pornography can be classified as obscene, such a ban would be considered substantial overbreadth because it would inevitably suppress protected speech. Moreover, banning online pornography entirely would require massive surveillance and filtering efforts, which could potentially infringe on privacy rights.
Thank you. In what ways is the Texas law a content-based imposition on speech? In what ways is it not?
So the Texas law may not be interpreted as a content-based imposition on speech because laws regulating minors' access to harmful material are generally considered a conduct-based regulation of access because their goal is to protect vulnerable groups, not to suppress the content itself. The law does not explicitly prohibit the production or consumption of pornography by adults. Instead, it seeks to regulate access, which the respondents may argue is a procedural safeguard rather than an outright content-based restriction. However, the Texas law should be considered a content-based imposition on speech because the law makes facial distinctions between material. By singling out the category of content that is harmful to minors, it regulates based on the subject matter of the speech. In Reed v. Town of Gilbert, the court held that any law that explicitly draws distinction based on subject matter is inherently content-based, emphasizing that although the intent behind the bill may be to target non-speech related goals, the regulation still applies according to the content of the material. Reed also stresses that the laws must be analyzed based on their practical effects on speech. As long as protected speech is still implicated, the bill is considered a content-based restriction. So, under First Amendment jurisprudence, laws such as this one are subject to strict scrutiny, as established in cases such as Erznosnik v. City of Jacksonville.
Is including social media and search engines under the age verification requirement a reason to find this law unconstitutional?
Including social media and search engines under the age verification requirement in Texas law raises significant concerns. Social media and search engines aren't intended to host explicit content. So by extending HB 1181's restrictions to these other platforms, it's causing so much trouble to users who weren't searching for explicit content. Because social media and search engines facilitate access to vast amounts of lawful information and host a wide range of content beyond sexually explicit material. So the law could result in substantial overbreadth, proving that it is not narrowly tailored to achieve its goal. This also creates a chilling effect because the mandatory age verification on such popular platforms might discourage users from accessing social media altogether, which also takes a huge toll on the platform's site traffic and economy.
Thank you. The law requires age verification when more than a third of the website's content is inappropriate for children. Would the law be more or less burdensome if the threshold was increased?
In practice, it would probably be less burdensome to increase the threshold, but it doesn't actually address any of the root problems that the one-third threshold created. It still imposes an age verification system on protected speech for adults, regardless of the size of the threshold, thus failing to address the significant burden on adults. Moreover, it is still overbroad because it bans all of the content on a website if a certain amount of content meets that threshold. Moreover, the 1/3 threshold didn't work because proportions are scalable. So websites that host a large amount of content can just keep their harmful content barely under 1/3, which can still be a substantial amount of content that minors would be able to access. Raising the threshold would only increase that amount. It doesn't change the nature of proportions, which depend on the size of the site to regulate content. Therefore, raising the threshold would improve the bill, but it doesn't resolve the inherent flaws that hamper the bill's constitutionality.
Ashcroft versus ACLU applied strict scrutiny to a law that burdened adults' access to online speech, not the rational basis test. Why should the court not apply the same standard here?
The respondents may argue that the Texas law only applies to a specific state, whereas Ashcroft dealt with COPPA, which was a nationwide act. Therefore, the language of COPPA, which includes phrases such as contemporary community standards, fail to apply nationally. However, the language of the Texas bill, which mirrors COPPA, can still apply to Texas, a specific community that the law affects. Even so, strict scrutiny applies regardless. The court should apply the same standard to HB 1181. COPPA regulated speech based on its content, and it took the Miller test basically word by word, which is meant to define adult obscenity, and applied it to minors. HB 1181 basically does the same exact thing. The Texas law restricted this kind of speech, imposing age verification requirements that apply specifically to websites hosting sexually explicit content, making it a content-based restriction. Under Ashcroft, such laws are presumptively subject to strict scrutiny.
Thank you. Ashcroft versus ACLU identified that content moderation through filtering settings was a less restrictive means of protecting minors online. Has that proven true in the time since Ashcroft?
As technology has advanced since Ashcroft, the underlying principle remains that any law restricting speech must use the least restrictive means. Advances in technology have also created more effective alternatives, such as parental control software and tools that are device specific. Filtering settings is an example of a less restrictive method because it makes it so that adults won't be burdened, just so children can be protected by making the restrictions device specific. They empower parents to raise their children without federal influence by allowing the parents to restrict access to certain content on certain devices for their children. Filtering settings are not only less restrictive, but they're also a lot more effective and address the main issues surrounding age verification policies. Children have VPNs to evade these state-bound restrictions, which essentially make the law completely ineffective. Courts in Playboy and Ashcroft v. ACLU overturned the laws after finding that there were less restrictive alternatives so the court should apply the same judgment here, as advancement in technology have provided incredibly effective, less intrusive alternatives for the court to use.
If the court were to find that the Texas law burdens the First Amendment right of adults, does that mean that petitioners win?
Yes, the petitioners do win. Strict scrutiny is applicable on the grounds that the Texas law unduly burdens adults' First Amendment rights. Texas already criminalizes obscenity for adults, so there's no need for HB 1181 to impose age verification on obscene material. As previously established, HB 1181 doesn't target obscene content, but material that is obscene for minors. However, a law that aims to prohibit children from accessing material that is not protected for minors is still subject to strict scrutiny if the law burdens adults' access to the same content. As this court stated in Reno, the level of discourse reaching a mailbox simply cannot be limited to that which would be suitable for a sandbox. By applying heavy unconstitutional burdens on adults in order to protect children, this law risks burning the house to roast the pig, which was said in Butler v. Michigan. Therefore, the law will require strict scrutiny and the petitioners will prevail.
Adults concerned for their privacy may not access websites requiring age verification. Is that sufficient reason for striking this law down?
If adults choose to avoid websites due to privacy concerns, it could be seen as a chilling effect on free expression. In Ashcroft v. ACLU, COPA was struck down in part due to the chilling effect it had on adults, even though the government had a legitimate interest in protecting minors. In that case, strict scrutiny was applied, significantly magnifying the issue because the law must be narrowly tailored in order to pass strict scrutiny. If the law's impact causes undue burden on adults, it may fail to meet the narrowly tailored requirement because it results in unintended consequences that widen its scope of impact beyond the intended target, minors. Under lower levels of scrutiny, the law may not be struck down if the burden on adults is deemed minimal. However, given that this law is content-based, strict scrutiny is the appropriate standard. Consequently, the chilling effect is a sufficient reason for striking this law down, as it prevents the law from meeting the narrowly tailoring requirement of strict scrutiny.
If the court finds that the law requires examination under strict scrutiny, does that mean that petitioners win then?
Yes, the petitioners do win. If the law requires examination under strict scrutiny, it's highly unlikely that it'll pass. First, the law isn't narrowly tailored because it's over-inclusive and under-inclusive in the content that it's restricting. If just 1/3 of the content is harmful to minors, then 100% of the content is restricted, making it over-inclusive. Furthermore, if the website hosts a large amount of content, then 1/3 will also be a large amount of content. And if a website doesn't meet that threshold, then it will not restrict that content that minors can still access. Additionally, by not listing the material that would be harmful to younger minors, for example, 5 years old, is not included, making it under-inclusive. FCC v. Pacifica Foundation states that even indirect sexual content can be inappropriate for certain audiences, particularly younger minors, as it can still be seen as having corrupting influence. By not distinguishing between different age groups within the monolithic category of minors, the law is further not narrowly tailored to protect all minors. Furthermore, HB 1181 also does not use the least restrictive means, as we mentioned previously. These flaws mean that it would be very difficult for the law to pass strict scrutiny, so the petitioners would win.
Are the privacy concerns presented by online age verification similar to the privacy concerns required to access age-restricted purchases in a traditional brick-and-mortar store?
Age verification online is drastically different from that in in-person stores. In the digital context, age verification can involve the collection of sensitive data that may be stored or used for profiling, creating a greater privacy risk. The data could also be subject to breaches or misuse across multiple platforms. HB 1181's requirements to delete data do not apply for data in transmission, so any intermediary between commercial websites and the third-party verifiers will not be required to delete the identifying data. This creates significant risks for the user's personal data as well as their intimate preferences, neither of which they would want to be leaked. On the other hand, the information provided in brick-and-mortar stores are transient, not stored, and bound to the physical location, which greatly reduces the potential for extensive tracking and profiling.
In the years since Ginsburg v. New York, have increased technology capacities increased or decreased the privacy concerns associated with age verification processes?
Since Ginsburg v. New York, advancements in technology have significantly increased privacy concerns. As said in the previous question, online age verifications are a lot more dangerous than transactions in traditional in-person stores. Advances in technology have made it much easier to collect and store personal information that could potentially be leaked. With the rise of digital tools, websites can track users' activities through cookies, IP addresses, and other tracking mechanisms. The storage of such data raises significant concerns about privacy, as it can be used for marketing, profiling, identity theft, and disclosure of preferences. So overall, technological advancements have created many risks for users that increase privacy concerns, which makes this law very problematic.
Online access to harmful materials presents unique obstacles to parents trying to protect their kids. If this law is found to be unconstitutional, what else can Texas do to protect minors accessing online material?
There are a variety of alternatives available to protecting minors without infringing on the First Amendment rights of adults, such as parental controls and filtering systems. Parental controls and filtering systems empower parents to regulate their children's online activities by blocking inappropriate content, limiting screen time, and monitoring usage. These tools, which date back to early internet platforms like AOL and NetNanny, have evolved with AI-driven filters and integration into devices and platforms. Studies show from Common Sense Media and Pew Research Center that they reduce exposure to harmful content and improve digital habits. The court in Ashcroft v. ACLU acknowledged that blocking and filtering software would serve as a more effective means of protecting children because the lack of extraterritorial enforcement was a significant flaw of website-based age verification. whereas a filter can prevent minors from accessing all pornography, not just pornography posted to the web from America, as directly stated in Ashcroft.
Counselors, do you have anything final to say to the court?
We pray that the court should send the case back to the Fifth Circuit, which will apply strict scrutiny in its review of HB 1181 and consequently determine that the law fails strict scrutiny.